Okay, it is Monday, June the 13th, 2022, and welcome to week number 6. This is it. This is the final lecture for this class. As you know, I'm your professor, Professor Richard Wright, and it's been my pleasure to be with you these last 5.5 weeks. Those of you who stuck out, some of you didn't completely go through, but everybody who hears this video are now still in the class. And I encourage you, again, as I say every week, to pay attention to what I say in the module, pay attention to what is in the rubric, and also pay close attention to what I say in the lectures. And I remind you in the lectures oftentimes of things that are so important that are in the rubric that I emphasize them in the lecture. So it's important that you pay attention to the lecture, not just to get the key phrase, but also to get the details of the instructions. So let's go ahead and start out by sharing my screen for the final time. And there we go. And as you can see, we look at the grade book. You will see that I have completed week 5 for everybody who turned in their assignment by the due date. There are still a few who have not, 2 and 4 written assignments. You still have time to turn them in. Remember, you have up to 7 days, but it won't go to 7 days because the course will actually end on Friday. So you want to get those in if you haven't gotten those in. So for week 6, we're going to talk about Hudson versus McMillan and the 8th Amendment. The 6th Amendment, I'm sorry, determining bail, which we will be discussing as well. And then your live classroom phrase for the final time. Let's take a final look at the calendar. Look at the month version. And you can see this is where we are, the 13th. And the lecture is scheduled for 7 p.m. Tonight, but I'm doing it earlier, so you'll have it earlier to get your assignments completed. Your initial post, of course, is due tomorrow, the 14th. Your reply post is due the 17th, along with your live classroom phrase and written assignment. The course absolutely ends on the 17th, and that after the 17th, you will not be able to submit any assignments. Okay? All right. Let's get out of that. So if you haven't gotten an extension, which I have not granted anybody, then you need to get that information completed. Okay. Seems like there's a video problem here. Let's see what's going on. Okay. Yeah, it seems to be working here. Okay. Let's get out of this just to see. Stop sharing because it doesn't seem like, okay, there it is. It's working. So let's go back to sharing. Okay, let's go back to the constitutional law class. Okay, so now let's take a look at the announcements for this week number 6. So today Week 6 module is about the Eighth Amendment and government authority. To prepare for the assignments, read chapter 12 of the text. I provided you the PowerPoints for that to correspond with that to help you prepare your written assignments. And we're going to talk about bail, sentencing, cruel and unusual punishment, and then we'll deal with a knowledge check. You can utilize these sources to help you with your written assignment along with the reading and what's in the PowerPoint. All right, so this tells you about the lecture, the discussion assignment, determining bail. Note the deadlines for the initial post. Again, it's tomorrow, Tuesday night, and Friday, 11:59 p.m. Central Standard Time for the reply posts. Not Saturday, but Friday, because the course ends. If you get it in after 11:59, all deals are off. Your written assignment, Hudson versus McMillan, the Eighth Amendment, and it's due by Friday the 17th. Again, and then I remind you once again down here to get your assignments in by Friday, and then make sure you complete the student survey. And I encourage you to finish strong, and you know about my motto, adversity is the springboard to success. All right, so let's get right into the Sixth Amendment. This is week 6. So let's talk about the written assignment first of all. Here it is. So you're going to look at a landmark case, which is Hudson versus McMillan, and examine the Eighth Amendment and write a research paper, and not a court brief, but a research paper. Now, that means you have to research the issues concerning Hudson versus McMillan. Now, pay close attention to what I'm saying. This is a 3-page minimum, double space paper, APA, which means citations throughout the body of the paper and citation in the end. In the process of writing this paper, you do summarize the facts of the case. But remember, you are not doing a court brief. Be sure that you use the official court case citation for Hudson versus McMillan. It's very important that you use that. Okay, and I will share it with you before this is over. But you'll lose points if you don't. Don't use OIS, don't use fine law. Identify common factors that a judge would consider when determining Hudson's bail after his initial arrest before his trial and sentencing. As you know, bail is one of the first things, and you know the purpose of bail, and I'll just tell you, is to guarantee the appearance of the individual. And individuals generally receive bail because you're not constitutionally entitled to bail, but to reasonable bail. In other words, the bail should be commensurate with the crime. And the more severe the crime, the higher the bail. The more that a person has had contact with the system, or a repeat offender or recidivist, likely the bail will be higher. And if there's no threat to the community for that individual, then bail. If there is determined a threat to the individual or to anyone, then the person will not be granted bail. Okay. Describe the factors judges must consider at the time of sentencing. Discuss his 4 views against Hudson was reasonable or unreasonable. Explain why the court and use the court decision. So cite the case. Remember, the first time you must cite it officially. After that, you don't have to. Explain why and use credible APA sources, including a reference page. Remember, cover page, double space, a minimum of three pages, okay? Minimum of 3 pages. All right. Correct spelling and grammar. And it must be, I said must be, I repeat again, in the form of a Word document. You don't see that here, but I keep saying it over and over and over. Very important that you do so, because I cannot grade the other form. I've expressed this before, but this is the final time you'll hear that. Let's take a look at the rubric. And as you can see, we're looking at the left side, okay, the mastery, outstanding summary, the significance of the case, factors for bail, factors for sentencing, use of force, and make sure you have credible sources throughout. You can have other credible sources in addition to the case, which is very good, make your paper better. And it must be a minimum of 3 pages long, double space, not single space, double space. Okay. If you don't have any credible sources or you don't cite cases, you're going to end up over here. If you cite cases, you could end up between here and here. All right. If you don't, for example, cite the official court case appropriately, you're going to end up with proficiency, because of the fact that I'm reminding you to cite the case officially. We'll talk about that in more detail in just a minute. Okay. All right. Okay. I guess I had to start the video all over again because it wasn't working right. All right. So remember, it's 3 pages, minimum of 3. Let's go to the discussion assignment, determining bail. I've already kind of talked to you about this. You'll apply the 8th Amendment to the scenario. Please be sure you cite the 8th Amendment when you're talking about bail as the origin. And remember, you're going to be considering the scenario up here. So in your initial post, discuss the factors that you must consider when determining bail and use the Bail Reform Act as your guide. Okay, make sure that you do that. And then what other information? Remember, you just have to do some background. Just research for the Bail Reform Act. Then reply post respond to another students. All right. A final time, you must post by tomorrow at 11:59 p.m. Central Standard Time. That's Tuesday. And then your reply post by Friday or before 11:59 p.m. Central Standard Time. So those are your written assignments, along with your class live classroom submission that I'll give you, and then the link. So we're going to talk about inserting bail and its limitations. We're going to talk about the Bail Reform Act that I talked about a few minutes ago, sentencing and cruel and unusual punishment, and then cruel and unusual punishment after sentencing. And then we're going to end with the knowledge check, just a quick review. So let's talk about what are we talking about? So as you know, one of the first things that happens when a person is arrested is to be brought before a judge and given the opportunity to post bail. And the bail gives temporary release of the individual while they're awaiting trial. And the Bail Reform Act, which came about, attempts to bring some parity so that judges, when they set bail, don't disproportionately affect people who are poor. Because one of the things that when bail is not granted is it increases the possibility of overcrowdingness in the jail, and sometimes even the loss of custody of children, loss of jobs, and so forth, even if they turn out to be not guilty. So bail is important. But as I said before, the primary reason is to guarantee the defendant's appearance at future court proceedings. Okay. And notice that it says in the language of the Eighth Amendment, excessive bail. Excessive bail shall not be required. Excessive. And I already explained that to you. Nor excessive fines, nor cruel and unusual punishment inflicted. All right. So we're going to discuss the bail. So now, bail is um, established under the Eighth Amendment and interpreted in a 51 case called Stack versus Boyle, and kind of gives an idea about what is excessive. Be aware that bail generally is determined on a case-by-case basis. But let's see what happened here. In this case, Stack had been arrested for violating the Smith Act that outlawed attempts to advocate, abet, advise, to teach government, violent government destruction. Well, we have something like that going now. The court set a fixed bail of $50,000 for each individual. The court didn't provide any evidence to support the bail. The court sided with the defendants and concluded that these methods were not reasonable and they were excessive. So they pointed out what some things that we considered. Arbitrarily setting bail, number one, is unacceptable, and there must be standards relevant to the purpose, as I already covered that. Standards used to set bail should be done at a hearing, and requests to reduce bail should be addressed. We attorneys file what we call motions to reduce bail, commonly if individuals are not able to provide it. And so in 1984, the Bail Reform Act came about, and to remind individuals that individuals, first of all, one, in criminal cases are presumed innocent until proven guilty, and that the main purpose should be what we stated at the outset, to ensure the appearance or to prevent defendants from reoffending while on bail, such as they'll tell them to stay out of trouble, don't get caught in another case. Okay. Now, there are various kinds of bails that you hear of. Cash bail, and generally cash bail is considered as 10% of the bail. So let's say if the bail is $50,000, then that individual usually posts cash or property in the amount of $5,000. Then there's what we call signature bond or I bonds or recognizance bonds, where individuals are released based on the probability that, number one, they will appear in court when they're supposed to, and they have not been in trouble or will not get into trouble, or that the offense is a minor offense, or it's a non-violent offense. Or there's property bonds where people post titles to cars and homes and things of that nature, stock and certain other types. All right. And so I've covered all of these things. So remember, the final thing I will say about bail is that it cannot be excessive, must fit the crime, and we consider the factors that we have already discussed. All right. And this is the Stack versus Boyle. There's the citation, and the Salerno case also is another. All right. So we deal with sentencing and cruel, unusual punishment. It says, and they use this scenario up front here, and it talks about this kid, 16 years old, and that he hung with the wrong crowd, committed a robbery where someone was accidentally shot and killed. The person was arrested and charged with armed robbery and felony murder because the murder occurred in the process of committing a felony. So the judge, pretrial process took several months and was not convicted until the individual was 18. So the question is, what type of sentence might the person face? Could John face life imprisonment for a crime he committed as a juvenile? Now that he is an adult, what factors should be taken? And all of these. We've learned already that the Eighth Amendment prohibits cruel and unusual punishment. So we're going to apply cruel and unusual punishment at the time of sentencing. All right, and it should not be cruel and unusual. So, as it says here, it's fair to conclude that cruel and unusual punishment doesn't allow certain kinds of crimes such as rack, thumb screws, giblet, or drawing or quartering. The key thing is that you don't want to cause the person to suffer too much. One of the questions that is settled, kind of, is the death penalty. And that was settled in 1972, where the United States Supreme Court banned and approved the death penalty. Now, in Furman versus Georgia, 72, the court looked at a combination of 3 cases where a person was convicted for murder and rape. Well, the court concluded that the death penalty was applied in an arbitrary or discriminatory manner, and that there was disproportionate effect minorities and poor people, and deemed as cruel and unusual punishment. All right. In a dissent, 2 justices concluded the death penalty was cruel and unusual punishment, but the majority of the court in Furman said that the death penalty was not legal. Okay. Was legal, I'm sorry, banned the death penalty, concluded that the death penalty was not legal. But 4 years later, in 76, in Gregg versus Georgia, the court concluded the death penalty was not cruel and unusual punishment and considered as a means of deterrence and retribution. I can tell you this, that we can tell you that there is absolutely no fact to the death penalty being a deterrent. People still committed crimes, still continue even to commit crimes, despite the fact that there's a death penalty involved, and that as a result, it really isn't. The only person who's really deterred is the person who is ultimately executed, and it takes a long time for a person to be executed once they're placed on death row. So what Gregg did was overturn Furman and forced Georgia to make changes to the sentencing, which try to take away the discriminatory aspects. So today, the death penalty is legal in 28 states and unlawful in 22 states. And what happens is, on a state-by-state basis, states did away with the death penalty. For example, Wisconsin doesn't have one. In 2000, I believe 14 or 15, Illinois did away with the death penalty after there's studies saying that it was too many individuals that were being placed on death row who ultimately were discovered not to be guilty of the crimes that they're charged. So we don't have a death penalty in our state. Now, so the states have the right to determine that. However, the United States Supreme Court has said in the case of Roper versus Simmons that it is cruel and unusual punishment to sentence to death a juvenile. That is, an individual who commits an offense of a criminal offense after 18 years old. That's Roper versus Simmons 2005 case. The citation will be shown to you later. All right. So when sentences are handed down, they should not arbitrarily be provided. There should be some sound rationale. And to be honest with you, many jurisdictions such as Illinois have what we call sentencing hearings where there is presented aggravation about the crime, and that's usually presented by the prosecution, reasons why the sentence should be higher. And then the defense will generally bring on witnesses and produce evidence to mitigate the offense, maybe about the background of the individual never been in trouble before, if the crime is even a violent offense. All of that is considered. There's usually testimony and or letters provided to attest to the family individual who was killed, presented by the family in mitigation. And then there's, aggregation. And then there is mitigation provided by testimony of people who knew the individual or individuals who were charged. So in the Solemn Court, the 1983 case, some examples that should be considered: the gravity of the offense and harshness of the penalty. That goes with what I've been talking about. Sentencing imposed on other criminals in the same jurisdiction. So there should be some parity, whether more serious crimes are subject to the same penalty or less, as I said earlier. And then the final point is that the sentence imposed for the commission of the same crime in other jurisdictions. So there is an examination to see what kind of set a standard for this. Okay. So now the Supreme Court has dealt with cruel and unusual sentences. One of the earlier cases is Rasmusssen versus California, a 1962 case where Rasmusssen was sentenced to a minimum of 3 months in prison for violating a law that prohibited people from being narcotics addicts. The court says, wait a minute, this is an illness, and imprison a person because they're an addict is cruel and unusual punishment. And so, or in other words, they're punished because of their status. And so it's unconstitutional to do so. So you can't do that. And it makes a lot of sense, but the direction that we're going in, if you take the drugs and crime course, you'll discover that we're moving towards recognizing that it's a health issue that we're dealing with when you have a person that is an addict. In 2003, in Lockyer versus Andrade, the Supreme Court examined the three strikes law, which we call the Habitual Offenders Act in our state, and result in a longer sentence. So it was 25 years to life for stealing $150 worth of videotapes. The court says, no, that's not good. Said that was cruel and unusual as a rare sentence and disproportionate. Think about it, goes back to the point, is that the gravity of the offense, and that's like there are people who actually have gone to jail for 5 years or so for stealing a loaf of bread. That's cruel and unusual punishment. And the Supreme Court, even as conservative as they are now, would probably overturn that. Finally, in the Graham versus Florida case, a 2010 case, the court and this is an important one that kind of goes with the case that I told you about a few minutes ago, and that is the Roper versus Simmons case. But it says here that um, if sentence a juvenile offender to life prison for armed robbery, is that cruel and unusual punishment? Sentencing for life. Well, the court considered the proportionality test that we talked about and said that life sentences for juvenile who commit non-homicidal offenses have been rejected the world over, and so juveniles should be allowed to atone and learn and have an opportunity to leave. So you can't sentence an individual to a life sentence unless there is a homicide involved, and they then could qualify for natural life if there's no death penalty in that jurisdiction. Of course, though, if they committed the crime before 18, they can't do it anyway, okay, based on the Roper versus Simmons case. All right. Some may be sentenced to death penalty case and spend years on death row awaiting execution. While incarcerated, the Eighth Amendment protects inmates from cruel and unusual punishment. All right. Now, so here are the citations. Notice the full court citations that are provided. All right. So now, cruel and unusual punishment after sentencing. And now we're going to get to the Hudson versus McMillan case, which we have the official citation that you will see here. Remember this for your written assignment. Okay, so after a person is sentenced, the sentence is to ensure that the convicted defendant is also in a safe and humane situation. The conditions shouldn't be inhumane, in other words. The clause also prevents cruel and unusual application of death sentences. Although the courts have never affirmed one death method over another, um, there is some considered as barbaric and torturous. So we're going to talk about now, finally, as we conclude, how the Eighth Amendment applies to the safe and human application, okay, of the death penalty as well. So cruel and unusual punishment within the jails or prisons applies to how individuals are treated. Are the guards deliberately indifferent? Do they attack or beat the individuals? Um, if a guard, for example, ignores an inmate's serious injuries, that could constitute cruel and unusual punishment based on Estelle versus Gamble, or starving the individual or something of that nature, or failing to provide mentally ill prisoners with treatment as well. So when prisons are overcrowded, as they frequently are, inmates sometimes have delays in receiving treatment, but ordering the release of a certain percentage of prisoners is constitutional, and that happens sometimes when we see that there is an overcrowdedness that takes place because the conditions for the individual to be there are inhumane, stacked up on top of each other and stuff like that. So now, if a serious injury or illness is inflicted by prison guards, such as I was talking about, unnecessary beatings, handcuffing, taunting them, denying bathroom breaks, this would be a violation of the Eighth Amendment based on Hope versus Peltzer. Prison guards are permitted to use reasonable force in good faith to maintain and restore order and prevent violence. However, maliciously, sadistically punishing prisoners just because they're there regardless of the type of even injuries sustained, is unlawful. This is when we get to Hudson versus McMillan, a 1992 case, which is the subject of your written assignment. All right, so malicious or sadistic harm violates the decency standards, and that's what Hudson versus McMillan will establish. As you look at that case, you'll be able to use that to answer your questions. Be sure you use the full court citation. It's given at the bottom here. Whenever force is used, correction officers must justify that force. It must be reasonable under the circumstances. Okay? And there's what we call a decision-making matrix that will evaluate the resistance, the circumstances, the officer's response, and the justification. All right. So in other words, the response must be in a commensurate to maintain control, but not so strong that you seriously injure or end up in unnecessary death. So let's talk about the death penalty. We've already learned that it is not cruel and unusual punishment, but there's some questions about the way that death penalty is carried out. So you have lethal injection, electrocution, and the firing squad are all constitutional. I find it very interesting that the firing squad is still around. Now, although not used in America, death by hanging has also not been deemed cruel and unusual. I would think it would be, and maybe if someone challenged it. But I haven't really seen that. The only state probably might consider something like that would be Texas, possibly Louisiana, but I know Texas would be one of those states. So the death penalty cannot be carried out by barbaric means. For example, did you not know that if a person is sick, they can't execute them? They have to wait till they're well in order to do so. So you can't like rip limbs from the body. You can't let them be drugged by horses, beheading, burning alive, and things like that. You can't do that as of 1800s. In addition to these examples, any method has to present what we call a substantial or intolerable risk of unnecessary harm. Probably commonly used now is electrocution and injection. Lethal injection is the one that I'm quite familiar with in most jurisdictions. So we're going to have a debate about the death penalty until the end of time. And there's an issue which it says that some believe the government should never determine who lives or dies. There's always a chance that a person is innocent. Well, that's one of the great things now that we have with the DNA that didn't exist when I first started practicing. And DNA evidence is used quite frequently now to exonerate individuals. And almost every jurisdiction you hear what we call wrongful conviction projects. Northwestern, my alma mater, has a great one and has resulted in individuals who were wrongfully accused being released when it's determined that they did not commit the offense. And there are others as well. And then these are the cases that were mentioned before. As you can see, Hudson versus McMillan, 503 US, the number 1, 1992. I want to see that at least once. If you use any of these others as well. Very important. All right. So don't say, well, I didn't get it. It's there. And then this is the matrix, which I'm not going to spend time on, but I'm just going to make you aware that this matrix is here. So it determines, is the subject verbally or physically resisting? Is the subject making attacks? These are all questions. The type of situations that are involved, the justification, the officer response, and then the justification. So that's a matrix that's considered. And all in all, what it really boils down to is what I said a few minutes ago, and that is that the sentence should be commensurate, or the penalty, with the objectives of serving justice and not excessively penalizing or punishing someone. So here's a brief knowledge check. So which amendment prohibits cruel and unusual punishment? So if you've been paying attention, it is the Eighth Amendment. Okay, then let's continue. Which factors must be considered by a judge when making a bail decision? The weight of the evidence and veracity of witnesses, the nature and seriousness of the charges, background and risk to the community, the nature and seriousness of the charges and the victim's background, and the nature and seriousness of the charges at the time. How about this? Yep. So I'm not going to continue. You can go through. Well, let's do one more. Which U.S. Supreme Court said it was cruel and unusual punishment to sentence someone to incarceration because the person is merely an addict? Is it Gregg? Is it Roper? Is it Solemn? Or is it Robinson? Gregg is the death penalty case. This is juvenile, so it's between these two. So it's actually this one. Solemn arrest the principal proportionality. Roper outlawed juveniles. What type of harm caused by correctional officers upon inmates always violates the Eighth Amendment contemporary standards of decency? Injuries caused during a cell entry to restrain a violent inmate. Injuries caused by malicious and sadistic treatment of prisoners. Injuries caused by reasonable force. This is the answer right here. Okay. And last one I'll do is, what is an example of barbaric means to carry out the death penalty? Is the firing squad, lethal injection, electrocution? Nope, it's this one. Drawing and quartering. And that's it. Okay, so you kind of have a summary of this. All right. Well, that's it. I've covered everything that I need to cover with you for this module. I hope that, excuse me, that you've been helped in this class. The key phrase I'm going to give you is Eighth Amendment. Eighth Amendment. You can write the number eighth, or you can write it out and spell it Eighth Amendment. All right. Well, I hope that you've learned in this class. This is just a thumbnail sketch. I try to enforce in you one of the things that's important when you start using the word law in a course, like constitutional law, criminal law. You want to get into the habit of citing cases appropriately. Those of you who have paralegal background know exactly why that is important, because when you use the official court citations, you allow the reader to be able to go and read the official decision issued by, generally what we use are United States Supreme Court cases. And it gets you into that vein. I'm not trying to be complicated, but I'm teaching you a good habit that you'll want to have. And it's really not that difficult, but one of the things that's so important in these assignments, and I say it over and over, is following the instructions. Following instructions. Well, this is the end for me. I'm going to be recovering. As you know what happened to me um, last week. I, I could have been not here, but I'm here. I'm resting, but I'm making sure that you guys are taken care of. Of course, if you need to reach me, you know how to reach me. Feel free to do so. I wish you guys the best in your future endeavors as you move forward. Those of you in this class, I believe, are on target for the Bachelor Completer course, getting your bachelor's, and I hope to see some of you at the next graduation. I usually see those that happen at the campuses in Romeoville, Mokina Tinley, Aurora, and then sometimes even the Rockford students come out, and then we have online students that uh, come out. Notice that even if you're all this whole program, criminal justice is online, but that even I um, don't teach on the campus because the program is online because I have students all over the United States, as many of you are. But the key thing is that I like to meet as many of you as possible. And again, I wish you the best. If you need any contact in the future with me, you know how to reach me. Feel free to reach out to me. I like to help students when I have an opportunity to do letters of reference. Sometimes it gets overwhelming for me. I haven't been able to do any now, but I will be doing some. Just reach out to me anyways. A lot of times I like to do phone interviews for individuals, and I have done a bunch of those for students. So, all right. So enjoy your break. Hope to see you in the future in other classes, and take care of yourself. Take care. Good afternoon, good evening, good night.